Clark versus Taylor.
Round and round we go. Nice to see everybody again. I've invited staff attorney for the front of the court, Megan Lipford here. Ms. Lipford, good morning. Thank you for being here.
Good morning, Your Honor.
Ms. McLean, good morning. Thank you for being here.
Morning, Your Honor.
And Attorney Matthew Reynolds appears on behalf of Mr. Taylor. Mr. Reynolds, good morning to you.
Good morning, Your Honor.
So I have read, I was able to track down the brief, and I've read that. I appreciate that, Ms. McLean, very helpful. Thank you. I've read the objections. Obviously, the objections are timely. Mr. Reynolds, this has really been a case of trying to get all the information from your client. It's been extremely frustrating from everybody on down to and including Mr. Baker from the front of the court. Anything in that regard you can tell me before I hear from Ms. McLean?
I can, Your Honor. After having been retained by Mr. Taylor, I asked him to provide to me documentation verifying his sources of income. Those sources of income do track what Ms. McLean thought his sources of income were. And so I have a statement from his federal employee retirement system. I have a statement from the military retirement system. And I have a statement from the VA as well. Ms. McLean's ideas of his amounts of income that were stated in her objection were almost spot on, but for VA, which is about $200 higher each month. So I have all of that information. I also have information showing the amount and when he received his inheritance. I think that having received that information and seeing that that establishes an amount of income that is actually higher than what his employment income was, it would seem to me that we could resolve this case fairly quickly.
Ms. McLean.
Thank you, Your Honor. I'm assuming that maybe at this point in time, just maybe with Mr. Reynolds' involvement, send it back to the front of the court with this new information and have them issue a recommended order. I have no objection to that. I just, again, my client's been very frustrated with this kind of failure to cooperate. Ask for something and failure to cooperate. It's been very frustrating.
Yeah, it's also been, and I can understand that. It'd be frustrating to me. It would be, it's equally going to be frustrating to Mr. Baker, but if Ms. Lipford can maybe bring a dozen donuts to him and see if he would be willing to rerun it with all this new information. Also, I would what I would like to do is just to make sure the record is crystal clear that that the parties, and I think we should do this with a signed stipulation, that Michigan can continue to exercise jurisdiction and that the provisions of the UIFSA found at MCL 552.2101 et sec will not apply in this case. So Mr. Reynolds, if you can circulate that stipulation, then we have it all clear on the record. I'll wait to get something from Mr. Baker's office and see if perhaps that does it. If not, the parties are free to contact my clerk if they think mediation would be helpful. Usually when I got two really good attorneys on it, that can get it done, but sometimes it can't. other than that, once we get that, we can just set up an evidence. I don't want to have to come back with you can file objections, but I don't need a hearing on it. Okay, if there's objections to it, just exchange them, make sure I get it, and then we'll just set it up for an evidentiary hearing after I receive those. Pretty clear, Mr. Reins, on what I need that stipulation to say.
I think so, Your Honor, but let me clarify. We would be stipulating that Michigan does have continuing jurisdiction regarding the issue of enforcement and modification of child support that MCL 552.2101 at SEC does not prevent the continuation of that exercise of jurisdiction. That this matter is referred back to the friend of the court for a new recommendation. I will provide to the friend of the court, to Ms. Lipford, if that's okay, and she can get that to Mr. Baker, the information I have. I will also copy that to Ms. McLean. We will get that new recommendation. If either party objects, we would simply file that objection and ask for an evidentiary hearing rather than taking up the court's time on another Friday morning.
Yeah, I don't want to have to wake up Ms. Clark at 0500 hours all the time, or Mr. Taylor. Ms. McLean, anything further?
No, thank you. I'm assuming Mr. Reins is going to draft that and send it to me.
I will do
Yes.
so.
Okay, thank you so much. Thank you, Your Honor. Have a great day.
Perfect. You too. Thank you all very much, and thank you for your service as always.
Yeah, well. Come on, you on the road.
I'm usually good for about one of those every motion cycle that someone just kind of hollers in when, when they jump on. So let me see if I can't restore some dignity here. First on my screen is the plaintiff, Ms. Moncha Torres. Ms. Moncha Torres, good morning to you.
Good morning, Your Honor.
And next on my screen is on behalf of Plaintiff Attorney Leslie Curry. Ms. Curry, good morning to you.
Good morning.
And finally, last but certainly not least, the defendant in this motion, Robert Durham. Mr. Durham, good morning.
Good morning.
I have read your motion. Is there anything you want to add, highlight, accentuate? I'll turn things over to you, and then I will hear from Ms. Curry.
Yeah, I'm just really, it gets me a little bit about paying child support for, I don't mind paying child support, but I want to be able to see my kids like I see the other two. That's basically one of my concerns. And then I wanted my child support a little bit lower.
Yeah.
And I have 0 overnights, 0.
Understood. See, that's one of the things with child support that's a little different from how everybody understands things is that when you make monthly payments for a car, you expect to be able to drive it. It doesn't work quite that way in the child support parenting time area. They are two separate tracks. I have a lot of men and women who have parenting time with their kids that don't pay any child support for one reason or the other. And I have a lot of people on my docket who are paying full child support and have no parenting time rights
Yep.
with their child. So it's frustrating. I get it. Ms. Curry, anything you want to add here?
Thank you, Referee Winter. I did submit a response to the motion that I'm assuming that the court had an opportunity to review. I
Yes, I
tried
did.
to lay out as clearly as I could, both for the court and Mr. Durham, each of the pieces to this and what I thought were the appropriate remedies and legal conclusions. So we would ask the court to deny the request to modify physical custody if that's a part of Mr. Durham's motion, because this order was just entered And there's no change of circumstances or proper cause since its entry. Regarding the request for joint legal custody and parenting time, we would ask that you refer that to the friend of the court for an evaluation and recommended order with the fees waived for both parties. And if you believe that you can make a determination as to interim parenting time in this little one's best interest before you get back the friend of the court recommendation, we would ask that you consider journeys for that under these circumstances.
Thank you. Well, one of the things that's interesting to me is that I know that ever since the case of Sims versus Verbrugge, 322 Michigan Appeal 205, 2017 case, there's been an uptick on requests for legal custody. The interesting thing about that Verbrugge case is that that only applies to DS support cases, because what the court in Verbrugge was trying to convey was that if paternity was established versus an affidavit of parentage or paternity, the language in that is not a judicial determination. The language, however, in a judgment of paternity is a lot different. And Verbrugge even points that out. When you have physical custody in a paternity matter, you also have the legal custody as well. But the defendant has filed a motion requesting a change of physical custody, and based upon case of Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case, this court needs proper cause or change of circumstances since custody was last visited approximately 70 days ago. The only thing that's listed are things that I give, obviously, a lot of credit to anybody for, such things as working at the same job for 7 years, having strollers, having all the facilities. I'm always troubled by when I read that he hasn't seen the child in 6 months. That is something that is concerning to me. Well, what I'm going to do is I am going to refer the issue of parenting time and legal custody to the friend of the court for an investigation and recommendation. I'm going to waive the fees for both parties. Obviously, legal aid's involved on this, and I will waive the fees for Mr. Durham as well. If there is going to, I have no objection to a referral to Journeys for parenting time. According to the response, apparently Mr. Durham, through maybe no fault of his, maybe fault of his, I don't know, but he has not seen this child who is, I think, 1, but a couple of times in 16 months, and that's somewhat, it presents a difficult scenario. I think what I'm going to do, though, Ms. Curry, is I'm going to defer that to a motion by Mr. Durham. If he wishes to have interim parenting time, he can file that with me. I don't have enough facts about the nature of his contact. I think that needs to be ferreted out, why it's only been that way. So I will reserve interim parenting time for a motion by Mr. Durham should he decide to do that. So you'll both be hearing from the front of the court. Make sure they have your correct addresses, that type of thing, because things will start happening fairly quick. Things get complicated from here on out, Mr. Durham. So if you feel that you can adequately represent your own interests, you may do that. But a lot of people find that they cannot. And if you are thinking about retaining counsel, you should probably do that pretty quick. Ms. Curry, anything else I can do for you?
Only referee Winther to remind Mr. Durham if he files a new motion that he should send me a copy. I filed a new appearance this time to clarify my representation. This motion was obviously more than 21 days after the last one was filed, but he did not get a copy to me. Instead, he sent it to my client. So I would just like the court to remind him that from this point going forward, he should send anything he files to me.
Yeah, that's Mr. Durham. That's what I was referring to about things getting more complicated. The court rules require that since Ms. Curry is representing Ms. Moncha Torres, that you can't even serve Ms. Moncha Torres with anything. You have to serve those documents to Ms. Curry directly. And if you fill out a subsequent motion to do that, you should do that or must do that according to the court rules to her directly. Anything further, Ms. Curry?
No, I'm assuming that the court will do the referral order to the friend of the court, and then would you like me to do the other order?
You can. I don't know what you mean as far as
I guess
making
just
sure
you
you're
order, you were reserving the
Yeah, you
the
can do that.
question of interim parenting time. I don't think there's much for me to put in that order, but if you would like an order, I can do so.
I think I should, and plus that would also reiterate the contact information you have so that Mr. Durham knows exactly where to send that. Mr. Durham, anything else?
No.
All right, you both are all set with me. Ms. Curry, always a pleasure. Thank you. And we're adjourned. You'll hear from the front of the court shortly. Make sure they got all your right information, okay? They don't forward mail. So hopefully we can get this figured out. Thank you very much. All right, you are Kelly Vanderveen.
Yes.
Good morning again. You and I have met before. I know that.
We have. Good morning.
In another setting, right?
Correct.
So, is Randall Vanderveen or anybody on his behalf present in the virtual courtroom? I don't see him. I see Mr. Is it pronounced Copen or Copen?
Copen.
Copen. Mr. Copen, good morning to you.
Good morning.
So I have, let me tell you what I know, and then we'll hear from the parties. Parties were divorced by consent judgment of divorce dated July 26th of 2023. The presumed father, I got to give everybody their titles. The presumed father, since the child was born or conceived during their marriage, is one Randall Vanderveen. The alleged father is with us today, Mr. Josh Copen. And the child in question, K.A.C., I'll use her initials, is less than 2. So apparently, all the parties somewhat, at least it's represented in the motion by Mr. Copen, that all the parties are aware of this, all would be willing to come into a virtual court and acknowledge this type of biological relationship. Is that what I'm reading, Mr. Copen?
Yes.
Okay, and Ms. Vanderveen, is that your understanding?
No, Your Honor, I would actually like to have a genetic test ordered for confirmation.
Okay, that can be done. The court will order genetic testing pursuant to MCL 722.1443 parent 5. You would have to prepare an order for that, Ms. Vanderveen. That would be at they'll help you with that at the Legal Assistance Center. They will prepare or help you prepare that order, and it has to be sent to me. I will sign that, and we will see once the genetic test results come in where we go from there. Okay.
Sounds good.
Mr. Copen, any questions for me?
Nope.
All right. Then the sooner you get to the Legal Assistance Center for that order, Ms. Vanderveen, the sooner we'll get this matter moving for you. Okay.
I can
Thank
go
you.
down there and do the same thing, right?
You can.
Okay, perfect.
Okay. If you want to do that, that's fine, Mr. Copen.
Oh, absolutely.
Okay. Then
Thank you.
you can do that and make sure I get a copy of it, and we'll, or because I have to sign the original, and then we'll get this matter moving.
Perfect.
Thank you.
Thank you.
Thank you.